Welcome to the Senate Committee. Today is January 9th, 2017. I think that might be the first time I said 2017 this year. But nevertheless, we're going to have a few reviews from the court agencies today. But before we do, I'd like to go through introductions and have members introduce themselves, perhaps where they come from, and any background that might apply to the Judiciary Committee. Senator Anderson, could we start with you?
Thank you, Mr. Chair. I think this is on. My light didn't come on, but anyway. I'm Senator Bruce Anderson. I represent a lot of Wright County, which is just to the west of the Twin City if you take Highway 55 or even 94 on the northern edge, along with Highway 12 on the southern edge. That passes right through most of my area that I represent. I have a little bit of Hennepin County with Rockford. This is my second term now to the Senate, and I was in the House for 18 years prior to coming to the Senate. I guess my forte is in veterans, being a retired veteran of 30 years with the military, and I look forward to being a part of the committee.
Senator Ralph.
Thank you, Mr. Chairman. My name is Jerry Ralph. I'm a senator from District 14, which is primarily the St. Cloud area, includes Waite Park, St. Augusta, and also a couple of townships in Sherburne and Benton County. I'm a retired 30 years as an attorney, after which I went and started a small business. I was a city attorney in southern Minnesota for about 11 years. So that's primarily the experience that I bring to the committee. Thank you.
Thank you. Senator Ingebrigtsen.
Thank you, Mr. Chair and members. Bill Ingebrigtsen, Senate District 8. I represent 8 townships in Douglas County, Alexandria being the largest town there, as well as all of Otter Tail, but 3 townships in the northeast part, which is Fergus Falls, Perham, representing West Central Minnesota. I have been in the Senate now. This is starting my 11th year. My first 4 years, I did serve on the Judiciary Committee. I have been off since then, but decided to come back. My background is law enforcement, 34 years in a squad car, the last 16, still in the squad car, but I was the sheriff for Douglas County, and upon retirement, I've been in the Senate since then. So, looking forward to the committee work this year in the Judiciary.
Senator Johnson.
Thank you, Mr. Chair. I'm Mark Johnson. I represent Senate District 1 up in northwest Minnesota. I have 6 counties up in that corner of the state. My background is I'm a licensed attorney, so I'm looking forward to being on this committee and the things that we can do here. Thank you.
Thank you. Senator Hall.
Hi, I'm Dan Hall. I am from Senate District 56, which is Burnsville, Lakeville, and Savage. Been on this committee for 6 years, probably my most enjoyable committee. And I work on the side for my son's law firm. I am not a lawyer, Jux Law.
Ms. Whittle.
Thank you, Mr. Chair. My name is Lily Whittle, and I'm the committee legislative assistant.
Ms. Cook.
Thank you, Mr. Chair. My name is Angela Cook, and I am committee administrator. Thank you.
I'm Warren Limmer. I come from Maple Grove. I represent Northwest Hennepin County, and I've been in the Senate, I think now I'm starting my 23rd year. Ms. Michelson.
Linnea Michelson, Senate Republican Research.
Ken Backus, I'm with the Office of Senate Counsel. I do the criminal side of the policy area, and I've been doing this for 23 years, all with this area.
Ms. Pontius.
I'm Kathy Pontius, Senate Counsel. I do the civil law and data practices issues, and I've been here for quite a while.
Mr. Turner.
Chris Turner, I'm the committee fiscal analyst with Senate Council Research and Fiscal Analysis.
One thing I might add is for the independent research staff that we have on this side, they have been with the Senate Judiciary Committee for quite some time, and they've served under both Republican and Democrat majorities, and we couldn't do our work without them. Senator Latz.
Mr. Chairman and members, I'm Ron Latz. I represent St. Louis Park and a few of the suburbs in the western tier of the metro area. I'm a lawyer by training and practice. I've got a solo practice. I'm a former Assistant Attorney General in Minnesota, where I served for 6 years in the Human Services and Public Safety divisions. I've done some private prosecution on contract. My practice consists mostly of criminal defense and plaintiff's employment discrimination, some civil litigation. I'm in the district courts multiple times a week, mostly Hennepin County now, but in the past it's been throughout the metro area and a bit around the state as well. And now the lead Democrat on this committee.
Senator Schoen.
Thank you, Senator Limmer. And, well, there's the feedback. I'm going to be the guy that's going to start that. 4 years in the House. I'm so glad to be over here in the Senate, and it's good to see the thousands of people in the crowd for our first hearing. I've been a police officer for 15 years in law enforcement, served about 4.5 years on narcotics and violent crime, which kind of led me into politics, working on federal and state cases that were pretty major cases. Before that, I've been a paramedic with a background in hazardous materials and teams and things like that. So I've got a wide variety in public safety, but glad to be here. I don't know. I grew up a farm kid out in western Minnesota, and are we getting into what movies we like or anything else? Or no? Glad to be here.
This is the Judiciary Committee. We don't care about that.
We don't watch movies.
Senator Pappas.
Thank you, Mr. Chairman and members. I'm Senator Sandy Pappas from St. Paul. I've been in the Senate since 1991. Before that, I was in the House for 6 years, where I believe the chairman and I both served on the Judiciary Committee or the Public Safety Committee in the House. But that's the last time I served on this kind of committee. So a little bit of a learning curve for me, like some of you freshmen, but I'm looking forward to the many hours of detailed discussion that we will have in this committee, right, Senator Hall?
One little story between Senator Pappas and I, we both served on the House Judiciary Committee at one time when I was a brand new state representative, and there was a particular horrendous hazing going on that Senator Pappas
Never going to let me forget that.
I happened to be the victim of that, and so not that it wouldn't ever come back again. We also have Charlie Bruce, or Charlie is our DFL judiciary researcher, and I know he's new to the committee. And Charlie, have you worked, is this your first year working for the Senate?
No, I've been with the Senate for 4 years. I mainly cover transportation and public safety and higher education, but now I'm judiciary and transportation.
So he's a veteran researcher, so that's great. Today we're going to begin our
Chairman?
work. Yes, Senator Latz.
If I may, before we get into the agenda, may I have a moment?
By all means.
Thank you, Mr. Chairman. I want to just take a moment to hand out a sheet for the committee's interests to elaborate a bit on the comments I made on the floor regarding the committee membership here. And I do this because I think it's a very important point for purposes of the legislative process, and I think it bears emphasizing. You will notice from the sheet that I'm handing out that the Judiciary Committee membership has historically not deviated from the majority membership by any more than 7 or 7.5%, and that's going back to 2003. 2004. And even then, the committee membership was 6-4. While I chaired this committee for the last 4 years, we had a deviation of 4%. We had a membership of 5-3 when the Democrats had an 11-vote majority in the full body of the Senate. Today, the Republicans have a 1-vote majority in the full body of the Senate.
but the Judiciary Committee membership is even more disproportionate. It is 6-3. It's a 3-vote majority, and it's a 2-to-1 ratio in this committee. It's an almost 16% deviation, which I think historically, other than perhaps the Rules Committee, which has traditionally had an excessive proportion because of the nature of that committee, historically, I don't think you'll find any other committee that has had this kind of a disproportionate membership. And I say this because I think it's important to the integrity of the process that we have in this legislature. This is a committee, above all else in the legislature, whose responsibility is to focus on fairness, justice, and due process. And the purpose of the proportionality rule is not just so that the minority doesn't feel bad being in the minority. It's so that when legislation goes through the committee process, by the time it gets to the Senate floor, it has been vetted in a process that is roughly proportional to the membership in the overall body, so that when it comes out, in whatever shape it comes out, it's got a greater likelihood of having generated consensus and to be in a form that is more likely to pass the full Senate body. So when we have a disproportionate number like we have today on this committee, it does a disservice to the overall legislative process. You know, I served on a city council in my community for 9 years, and we were very focused on making sure that the process was a fair one. And we found over the course of many very contentious issues that if you had a process that was fair and that was viewed as fair by the participants, the observers, the community members, and those making decisions, then the outcome was viewed as legitimate. When the process was not fair, the outcome was delegitimized. I understand at the opening session there were some references to religious motifs, and I'll hark back to that, which I don't ordinarily do in this body, but it's kind of like an original sin. We're starting out undergirding this entire legislative process with a core trait that can't be changed, and that will infect the entire legitimacy of the outcomes of the process of this committee. I am convinced that this committee, with a 6-3 ratio, was designed with the intent of being a recipe for railroading the minority members on controversial issues, essentially neutering the voices of the minority members in this process. Now, that said, I do intend to work very seriously on this committee, as I did as chair, as I did as minority lead before that when Senator Limmer was the chair of this committee. I have a very positive and productive working relationship with Senator Limmer and with Senator Hall and with Senator Ingebrigtsen from our previous service on this committee as well, and with Senator Anderson from our time in the legislature together. And the new members of the committee, I look forward to meeting you and working with you and finding common ground where we are able to do that. It is my hope that by the end of this legislative process that we will indeed find common ground on issues. We will work to make the legislation that comes out of this committee the best that it possibly can be, and that it will be ready for enactment into law, because that's how I viewed the role of this committee, and I know that's how Chairman Limmer approached this when he was chair before. But I couldn't let this beginning day of this committee go without expressing my deep disappointment with the membership on this committee in terms of numbers and the impact that I think it will have on the overall legitimacy of the outcomes from this committee. Thank you, Mr. Chairman.
Thank you, Senator Latz. Going back to our agenda, we're going to be hearing from the State Court Administrator first for approximately 30 minutes, and that should include any question and answer time during that 30 minutes. Hopefully, if I know that the court administration told me earlier that they may have to leave early, so if they have to leave early, we understand. But would Mr. Shorba come to the testifying table? Would you identify yourself for the record?
Jeff Shorba, State Court Administrator for the Minnesota Judicial Branch.
Thank you. Please
Mr.
proceed.
Chair, members of the committee, as I said, my name is Jeff Shorba, and I serve as the State Court Administrator, the administrative head of the Judicial Branch. I'm happy to be here today to present to the committee an overview of Minnesota's third branch of government. The Judicial Branch's mission is clear, to provide justice through a system that assures equal access for the fair and timely resolution of cases and controversies. We take each word in this mission statement very seriously, especially ensuring our system is fair and our cases are resolved in a timely manner. And I will discuss that in a little more detail as we get into some of our performance measures for the Judicial Branch. The work of the Minnesota courts is, I'm not having the, thank you. The work of the Minnesota courts.
Pardon me, Mr. Chairman.
Yep.
Oh, the screen just popped on.
Oh, okay.
I was wondering if you had any things to view. But,
Oh, yeah.
And members, there's also in your packets this document that you could follow along on your own paper in front of your desk. Please proceed.
Thank you. The work of the Minnesota courts is a core government function addressed in the first article of the Minnesota Constitution. The Constitution guarantees that all Minnesotans are entitled to obtain justice without purchase completely and without denial promptly and without delay. Every Minnesotan under our Constitution is entitled to a remedy in both criminal and civil cases. The Judicial Branch has 317 judges and approximately 2,500 employees. The branch handles 1.3 million cases in 106 locations with a biennial general fund budget of $638 million. Interestingly, the Minnesota Judicial Branch operates in more geographic locations than any other part of Minnesota state government. The Minnesota Judicial Branch is fully state-funded, and I'll talk more about that in transition, which occurred in 2005. And this budget funds the judges, staff, and operations for all trial courts, the Court of Appeals, the Supreme Court, the State Law Library, and the State Court Administrator's Office. Minnesota has a streamlined three-tier structure of 2 appellate courts and a single trial court called the District Court. The Court of Appeals was created via constitutional amendment in 1983 to help deal with the large number of appeals from the trial courts. The Supreme Court has 7 members who hear and decide cases as a group. The Court of Appeals has 19 members who hear cases in 3-judge panels, and the trial court has 291 judges. The 7-member Supreme Court hears appeals via what is called a petition for further review, or PFRs, from the Court of Appeals, the Tax Court, and the Workers' Compensation Court of Appeals. A PFR is filed when a litigant wants to have their case heard by the Supreme Court, and the Supreme Court then decides whether they will take those cases. In addition, there are what we call original actions, meaning these kinds of cases go directly to the Supreme Court from the trial court. Those would be first-degree murder convictions, bypass the Court of Appeals. If there are any legislative election contests, judicial and attorney discipline are also done by the Supreme Court. In addition, the Supreme Court regulates the practice of law, and what we mean by that is requirements for who can be licensed as an attorney, requirements for continuing education, et cetera, are also the purview of the Supreme Court. The Court of Appeals hears appeals from trial court decisions, administrative agency decisions, and the Commissioner of the Department of Employment and Economic Development. And those would be unemployment insurance claims. The Court of Appeals has original jurisdiction to hear what are called writs of mandamus or prohibition, which is a type of compelling of a trial court, corporation, or public authority to do or forbid from doing something. Those go directly to the Court of Appeals. Obviously, the largest amount of work in terms of volume is done in the trial courts, where our 291 judges operate. They have original jurisdiction, a variety of case types, as you can see here on the slide. We also have a conciliation court division, which hears small actions up to a $15,000 limit in those conciliation court cases. This slide shows you how the filings among the trial court are allocated. These numbers are from 2015. We divide cases in the trial court into major cases and minor cases based on the amount of time they generally take to handle. So major cases, of course, would include our felonies, contract cases, personal injury, malpractice, property damage, employment. Minor cases would include those conciliation court cases, unlawful detainers and landlord-tenant disputes, misdemeanor DWI, traffic, parking. Those would be the smaller number of cases. Since FY12, fiscal year 12, the judicial branch has seen an increase in the number of major case filings and an increase in the complexity of cases brought to the trial courts. The most marked increase is in cases where we have children in need of protection or services or permanency cases, which have seen a 56% increase in filings from fiscal year 12 to fiscal year 16. In addition, major cases, major criminal cases, felonies, and gross misdemeanors have risen 12% during that time period, and drug-related case filings have increased 25% over the last year. So although some of the minor cases may be going down, we are definitely seeing more time spent on the major cases in the trial court.
Mr. Shorba, could you review that 56% increase one more time? What category was that again?
Sure, Mr. Chair, category, these are what we call CHIPS cases, or children in need of protection. You may obviously have heard about the governor's task force on this issue, which has generated some additional work in the trial courts. We've also seen staffing, social work staffing going up in especially Hennepin and Ramsey, but some surrounding jurisdictions. So we're seeing more cases generated in this area, and that's why they've gone up dramatically.
Mr. Shorba, is that based on just more staff getting involved in these cases, or is there a public awareness that's been raised due to the news stories or the governor's commission? Do you know a little bit more about that? I'd like to know why we have 56% seems to be an alarming increase.
Mr. Chair, I can only surmise from discussions I've heard with our trial court judges about this that we are seeing more public awareness. We are seeing increased staffing on the social work side, so they are generating more cases. It's probably a better question for some of the county officials who are filing them, but you will see as we come forward with our budget request, it is generating greater judge need, especially in some of our jurisdictions.
Would you think, Mr. Shorba, that that activity directed against children is a constant in the state of Minnesota based on this figure, or is it just because now we have, it's kind of like crime rates go up when you put more police on the street? Well, of course you're going to have an increase because there's more eyes out on the street to find it. Is that the same result, or is that something that there's a constant activity out in Minnesota all the time?
Mr. Chair, again, I can only surmise we are trying to monitor the numbers to see if, as you're suggesting, this is some kind of a blip in the radar or if it will be a constant. It's probably a little too early to tell right now.
All right. Thank you. Please proceed.
Our trial courts operate in all counties, but we are organized into 10 judicial districts for administrative purposes. These districts also serve as election districts for judges, which I'll talk about in a minute. We have 2 single county judicial districts, as you can see from the map, the 2nd district in Ramsey and the 4th district in Hennepin. The other 8 are multi-county districts ranging from 4 counties in the 6th district to the largest district, which is the 9th up in northwest Minnesota. And you can see that has 17 counties and covers nearly a quarter of the state. I know that you're going to hear from the Board on Judicial Standards, but just a little information on how judges become judges. Supreme Court and the Court of Appeals judges are elected statewide to 6-year terms. The District Court judges are elected district-wide, so you run in your own judicial district to 6-year terms. And if there are midterm vacancies, they're filled by a governor. The statutes require that the governor use the resources of a judicial selection commission to vet the candidates for trial court vacancies. Many governors have also chosen to use that for appellate and Supreme Court vacancies. Complaints with regard to judges are handled by the Board on Judicial Standards, which has 10 members, all of them appointed by the governor. And then the Board on Judicial Standard can recommend discipline for judges to the Supreme Court. The Chief Justice is the administrative head of the judicial branch and responsible for overall management of the judicial branch. As some of you may know, in 2005, we instituted a new policymaking body called the Judicial Council, which was organized in conjunction with the transition from county funding of the court system to state funding of the court system, which occurred in July of 2005. The State Court Administrator's Office, my office, serves as staff to the Judicial Council, and we provide administrative support for areas such as human resources, finance, information technology, et cetera. The Chief Justice leads the Supreme Court. There is a Chief Judge of the Court of Appeals who is appointed by the governor for a 3-year term. And then there's a Chief Judge in each of our judicial districts who are elected by their peers to 2-year terms.
Mr. Chair.
Senator Ingebrigtsen.
Thank you, Mr. Chair. Mr. Sorbo, could you just go back to the Board of Judicial Standard, 10-member appointed by the governor? Can you tell me, are they all judges that are appointed onto that committee?
Mr. Shorbat.
Mr. Chair, Senator Ingebrigtsen, they are not all judges. I think there are 2 judges maybe, but they are not all judges.
Are they from,
Senator Ingebrigtsen.
Mr. Chair, are they jurisdictional wise, one from each district, or how is that the makeup of that? Do you know?
Mr. Chair, Senator Ingebrigtsen, I do not believe that they are jurisdictionally, but maybe Tom Vasily would answer that better. I know that there are some public members, so there are some attorney members, and there are some judge members on the group.
Senator Ingebrigtsen, on your number 4 item on the agenda, that individual may be able to answer your questions a little bit better.
Thank you, Mr. Chair.
Please proceed, Mr. Shorbat.
So as I mentioned, the Judicial Council is the administrative policy-making body for our judicial branch. It's comprised of 25 members, 19 judges, and 6 administrators, and the Chief Justice serves as the chair. The primary responsibilities for the Judicial Council are vast. They set many of our policies within the judicial branch. We put together a biennial strategic plan that the council approves and that is implemented by my office for the branch. They set our legislative agenda, so we'll be coming this session with a budget request, which we'll talk about at another hearing, as well as some policy bills. Those are set by our Judicial Council. Any funds allocated by the legislature are allocated out throughout the branch by the Judicial Council. And then we spend a lot of time ensuring that we are performing well within the judicial branch, and that is also the purview of the Judicial Council. We have 6 core judicial branch goals with regard to performance measures. You can see them here on this slide. Many of these are measured by surveys. So every 2 years, we survey our court customers in both the appellate courts and the trial courts who come in to see if they believe they're getting proper service. We survey members of the bar. We survey our own employees and judges, which is called our Quality Court Workplace Survey. We also measure how we are doing in handling cases. How long is it taking them to get processed through the system? What is the length of pending? How many are we turning over every year versus getting in? So the council spends a lot of time on these performance measures, and I know that we have talked about these performance measures with this committee before, and we'll be coming back and talking about some of them as we go through our budget request. One of the things I just wanted to cover for sure with the committee has been one of our major initiatives to date, which has been our multi-year transformation to replace paper-based court records with an electronic information environment, which we call eCourt Minnesota. The judicial branch undertook this initiative in order to provide the type of convenient online service our customers and those we serve expect, while also increasing efficiency within the judicial branch. It began in 2010 when Hennepin County, our 4th judicial district, began to pilot the electronic filing of case records. And on July 1st of 2016, e-filing became mandatory for all case types in all courts, both district and appellate, within Minnesota. We believe that this has helped our court customers. They can now get 24/7 access to court documents. They can get documents at any courthouse terminal for cases throughout the state. So if you go to a terminal in Hennepin, you can see cases from Bemidji or Duluth as well. The public now has expanded access to these court records via these terminals. We've developed new tools for judges and court staff to use to help manage and process these cases electronically. And law enforcement, county attorneys, public defenders, other government partners now have electronic portals where they can have access to court documents. Our appellate courts, as I mentioned, have also transitioned to a paperless world effective July 1st, 2016. Just to give you a little idea of the volume, we're averaging more than 260,000 documents being filed electronically into our case management system each month. This equates to more than 1.75 million documents e-filed during the first 6 months of mandatory e-filing. Our case management system now electronically sends out messages to our government partners at the rate of about 280,000 messages per day. So instead of taking a paper document and walking it down to probation, these are now all sent out electronically. So we certainly have made a lot of progress here. We still have some things to go, which I'll talk about in a minute, but it has been a major initiative within the courts.
Senator Schoen.
Thank you. Can you tell me what are the maybe top 3 documents then that are shared daily? If you're at that level, who are the biggest users as far as what documents are coming in? Is it coming from law enforcement? Is it coming from probation? What are they? Are they citations? Are you using that as saying that that's 285,000 because of, that's my question.
Mr. Shorba.
If that question makes sense, Mr. Chair.
Mr. Chair, Senator Schoen. The biggest would be lawsuits filed both in the civil area as well as criminal complaints. This does not include our e-citations, which are also, as you know, filed electronically by the law enforcement, so we're not receiving paper there as well.
Yes, Senator Latz.
Mr. Chairman, Mr. Shorba, has there been any discussion about giving lawyers expanded access to the electronic records in the judicial system? For example, remote access to name searches to get cases rather than just having a case number, which can be done at the terminal at the district court, but can't be done from a law office, for example, and to the documents that are in those legal cases, for example. There's a reference on the Register of Actions, for example, that a complaint was filed, but remote access from a law office, you can't pull up the complaint.
Mr. Shorba.
Mr. Chair, Senator Latz, that is one of our next initiatives. The council has been discussing it last month and this coming month, and we hope to be able to choose a way of going with that, whether that's with our current vendor for our case management system or doing it in-house. That's a decision that the council will make this month, and then we'll be moving forward with remote access, not only for attorneys, but also for members of the public. So both of those are on our next agenda.
Please proceed. Please proceed, Mr. Shorba.
Some other initiatives I wanted to talk a little bit about to bring the committee up to speed on them. One has to do with self-represented litigants. We're seeing a growth in the number of people who are coming into court representing themselves, and so we're trying to expand services to self-represented litigants. The Minnesota Statewide Self-Help Center provides assistance to litigants across the state by help topics on our public website, answering questions via phone and email. To give you an idea of the volume, in 2015, the Self-Help Center provided one-on-one support to over 25,000 Minnesotans via email and phone who had questions, and that doesn't include the number of people who went to our website to get forms. In all of our court locations, we have a terminal and a phone set up where people can either log on and get email support from the Self-Help Center or pick up the telephone and speak to one of the attorneys working in our Self-Help Center. They can also print off forms. In addition, several of our districts now offer walk-in support for self-represented litigants, and including the State Law Library, where in 2016 we launched a new self-help clinic to provide free assistance to individuals seeking to file an appeal with the Minnesota Court of Appeals and the Supreme Court. We're one of 7 states that recently received a grant, a federal grant, to try to increase our level of self-help. So we're really become a national leader in this particular area. The second initiative I want to mention is what we call our Conservator Account Auditing Program, or CAP. It's a nation-leading initiative to protect the assets of vulnerable individuals. As the population in Minnesota grows older, we're seeing more individuals who have the need for a conservator. And what we've done is modernized and improved the way that we handle those cases through the CAP program. Prior to the CAP program being an initiative, conservator records were submitted via paper, sometimes with a big box full of receipts that would be brought into the courthouse. And now we have an electronic way to submit those expenses by conservators. The system is also developed so that it can have a red flag if there seems something a little bit suspicious or fishy with the account program. And then we have a group of auditors who look at those particular accounts on a regular basis. To give you some idea of the scope, today the program is monitoring the assets of almost 6,000 vulnerable individuals in Minnesota with assets totaling more than $908 million. And we're already seeing the benefit of this program. In nearly 12% of the cases audited under the program, auditors have found concerns of loss, inappropriate loans or expenditures, or commingling of funds, and those auditors have been able to recover funds. The court has been able to take action based on the tools that we're using through this program. Lastly, in 2016, we completed the transition of our 2nd and 4th judicial districts to what we call the Court Payment Center. This means that all payable citations are processed centrally rather than having that work spread across 87 counties. We offer very convenient online and over-the-phone payment options, so we've made it easier for our customers to deal with these particular cases. And we've received a number of awards nationally for this program as a very innovative way to handle these smaller, minor cases, but in a much more efficient manner. Another service delivery redesign of which we are very proud is the creation of a number of drug and other treatment courts around the state. Over the past several years, Minnesota has experienced a significant expansion of drug courts, veterans courts, and other treatment court programs across the state. Today, Minnesota has 58 treatment courts, either currently operating or in the final implementation phase, including 11 multi-county programs for those smaller counties that may not have the volume necessary. The judicial branch provides funding through appropriation from the legislature for 27 of these 58 courts. The rest are funded either through state grants from the Office of Justice Programs, Department of Human Services, or federal grants for a total biennial budget of approximately $10 million. Treatment courts are really just specialized calendars within our trial courts, but they really represent a shift in the way courts are handling certain offenders and working with key stakeholders in the justice system. So we work very closely with prosecutors, public defenders, social workers, probation officers. Treatment courts have been extensively studied, not only nationally, but also here in Minnesota. Since 2012, we've conducted 3 statewide evaluation of treatment court programs where we look at a cadre of individuals who've gone through the treatment court and compare them to individuals who have not. And it has shown that treatment courts reduce recidivism among participants, provide long-term cost savings in the criminal justice system, and also better outcome for offenders struggling with addiction, including higher rates of employment, stable housing, and educational attainment. I'm going to talk more when I come forward to you with our budget request about trying to provide funding to sustain these treatment courts here in Minnesota.
Mr. Chair.
Senator Hall.
Thank you, Mr. Chair. Mr. Sorba, could you explain what, on these treatment courts, what hybrid is, what family dependency is about, and tribal to wellness?
Sure.
Mr. Sorba.
Mr. Chair, Senator Hall, I also have our state drug court coordinator here if the questions get really hard. The hybrid courts means that somebody may have a family dependency issue where their children may be taken away from them, but they also have a drug issue. And so we're trying to deal with both of those issues in a hybrid way. The wellness courts, tribal wellness courts, are ones where we have teamed up with tribal courts. So the judge from our district court and a judge from the tribal court are working together to try to deal with issues that have arisen on the reservation as well as issues that have arisen in our state court, many of them tied in with addiction and drug issues.
Mr. Chair, and
Senator Hall.
Did you explain the family dependency court, what that is?
Family,
Mr. Shorba.
Mr. Chair, Senator Hall, family dependency would be the situation where we have a child in need of protection kind of case, and the issues arising from that stem from the parents' drug issues, and so we're trying to deal with it as if it were like a treatment court, trying to make sure that there are those treatment resources. And we find that often in those cases, when we sort of use that treatment court model, we have better response from the individuals.
Please proceed, Mr. Shorba.
So, in conclusion, I want to briefly outline our present and future activities and focus. We have been and continue to be committed to three major goals. One is providing court services in a manner that is focused on customer convenience and access. Secondly, ensuring the public trust and confidence in the judicial branch through efficient and effective court operations. And thirdly, working very closely with our justice partners to strengthen the justice system. As you've heard a bit this afternoon, we've accomplished so much in the past several years, and our technological advancements have helped make our courts more efficient and more accessible to our customers. However, as seen from the question from Senator Latz, we still have more work to do. Our challenge now is to look at the technologies and try to harness them in a way that will help us to even better expand our services to the people around Minnesota. So our staff and our judges are working to redesign their work to now take advantage of this electronic court record. We now are able to move work across the state. Doesn't necessarily have to stay in the jurisdiction where it's filed because we don't have to transmit paper. So, for example, where we might have some challenges in greater Minnesota where population and the case filings might be going down and people may be saying, how can you keep this courthouse open? We can now move work from other jurisdictions to keep the staff busy and also allow them to be there for those people in those smaller counties and areas to have a courthouse to come to and a place to file their papers and answer their questions. So I look forward to reporting back more in this session as we come forward to you with our policy bills as well as our budget request to talk about these future efforts. Thank you, Mr. Chair. I'm available for questions.
Thank you. Members, do you have any questions? Senator Anderson.
Thank you, Mr. Chair. Mr. Shorba, as we look at the state of Minnesota and I look at the map of all the courts throughout the state, how is the electronic or the technology available to the courts out there? Does it have a negative effect on your ability to go forward and carry out the communication back to, say, the St. Paul or to wherever your location is? Are you being affected by the broadband issue at all from the court standpoint?
Mr. Shorba.
Mr. Chair, Senator Anderson, we have spent considerable time and resources trying to ensure that the broadband issue is dealt with as efficiently as possible. We work closely with the executive branch, Minnesota IT, to put down better lines to some of our more remote locations. We're sort of dependent on their expertise since they are sort of building the statewide broadband, but we have tried to join with them as much as possible and provide some resources to expand it. So we've done a lot of work. There are still some remote areas where it's a little bit more difficult. For example, we've worked to make sure that there's wireless now in every courthouse across the state so that people can gain that access. But as you know, there are some remote areas where somebody may not have the kind of access from their home, but we've generally been able to be successful at getting it at least into the courthouse area.
Senator Schoen.
Thank you, Mr. Chair and Mr. Shorba. Mr. Chair, my question is going to be about budget, and I do know that you're going to come forward, but it's helpful to me to kind of have an idea, since this is kind of the, we'll say, minus some debates we'll probably have later on in the week on other issues, but it's nice to have in the back of my mind what are going to be the priorities budgetarily for courts. And by that, I don't mean you don't have to list out everything, but I'd like to give, and I'll go back to my top three. What's going to be the top three things that are going to be either new or are going to be bear the brunt of your request of budget requests? And Mr. Chair, I would assume that sitting here today that the courts have had all fall to look back and determine that this is where we're going to go. And I noticed that now we're calling, we're doing an umbrella, calling them treatment courts or beyond specialty courts or whatever. So that was a new term to me. I hadn't seen that yet. And so I'm curious, where are you looking at as funding for that as well, too? What might be the increased request, or is that not in the top three? Or just give me a highlight, and I won't even question you on the whys for today, but I'd like to know in the back of my mind where you're going.
Mr. Shorba.
Mr. Chair, Senator Schoen, I'm happy to talk as much as you want about our budget request. We have approved a budget request by the Judicial Council. We have sent it on to the governor. We're hopeful the governor will include it within his budget request at the end of January. It is about a 7.9% increase to our budget. There are 5 major areas. One has to do with compensation for judges and staff. The second has to do with some of the caseload growth that we're seeing, as I mentioned, in major criminal and child protection cases. So we'll be asking for 2 new judgeships at the district court level. There is funding. The Judicial Council just adopted this new umbrella term of treatment courts, so that's why it's probably new to you. So we will be looking for some funding for treatment court stabilization. We're seeing an increase in 2 areas, what we call mandated services. These are areas that we have to do via statute. One of them is payment for psychological exams for individuals who are coming into court. We're seeing an increase in the number of those with mental health issues in our state. So payment for those psychological exams has gone up, as well as some of our interpreter costs. So those will be 2 aspects we'll talk about. And then the last area has to do with cybersecurity, and we'll talk to you more about what that entails when we come forward. We'll also, Chief Justice and I will be setting up meetings to talk with each of you individually about our request.
Thank you.
Senator Schoen.
Thank you, Mr. Shorba. And Mr. Chair, I will just make one quick comment about a point you made earlier related to the child protection and the 56% increase. And I think it's a great example, as Sheriff Ingebrigtsen would know, if enough people complain or there's enough noise about speeders on a particular area, and I send 4 officers out there to do traffic enforcement, I can guarantee you that very quickly we're going to have about 160% increase in speeders in the area, because that's data we're going to track, and this has certainly made the news. But the most, I think the biggest reminder to us is that when we just can't pay lip service to this stuff, because we did all that work with the Child Protection Task Force and other things, but the funding, I mean, there's a trickle down. I mean, and for all the years that I've been in law enforcement, we've seen the needs for child protection and the work that gets done, and we see so many kids that get referred, and you're like, well, how did that not get more attention than it did? And now people are just, and I hate to say it in a way that sounds somewhat demeaning in a way, but sometimes now people are just doing the job they should have been doing before. And that's going to cost money all the way to the bottom.
Mm-hmm.
So what? Look forward to that 7.9% increase and see where we're going to come up with that and make some things happen across the board, because it's not just going to be in courts. It's going to be in probation. It's going to be corrections, and it's going to be a big haul.
Thank you, Senator Schoen. Senator Schoen, do you believe then in trickle-down economics?
Well, you know, I think...
you don't have to answer that.
Oh, I'd be happy to. I think there's a lot of things that I believe in that were President Reagan maybe believed in, and I realized that that wasn't exactly the reference. But we can go back and find some people that were pretty moderate that wanted to work together and would raise revenue when it needed to be raised.
I think you'll find that here, Senator Schoen. Senator Ingebrigtsen, and then we've got some other guests coming. Senator Ralph, did you have a question too? Senator Ingebrigtsen.
Thank you, Mr. Chair. Just real quickly, if somebody from your office can stop by and see me and help me with a guardian issue that I have, a constituent that wanted to terminate their function as a guardian for a vulnerable adult in August, and that court has still not heard that letter of resignation. It goes beyond my whole thought process of why we would tie the courts up doing something like that when this person wants to quit doing this. I just need somebody to come. I don't want to take too much committee time. That'd be great. Thanks.
Mr. Chair, Senator Ingebrigtsen will be happy to stop by.
All right. We are out of time for the court administration, and thank you, Mr. Shorba, for your testimony. We'll be now asking Mr. Robert Small, Director of Minnesota County Attorneys Association, to give testimony. Welcome to the committee. Would you identify yourself for the record?
Thank you, Mr. Chair, members of the committee. My name is Robert Small, and I'm the Executive Director of the Minnesota County Attorneys Association. Thank you very much for the opportunity to provide this committee an overview of our association. With me today is Nancy Haas. Ms. Haas is the lead lobbyist for our association. She's been the lead lobbyist since 2006. Behind me is Ben Schweikert. Ben is an assistant Hennepin County attorney, and during the session, he spends a dedicated portion of his time working with us on issues of common interest. Our president is Mr. Jeff Edblatt, the Isanti County attorney. Mr. Edblatt planned to be here today, except he was called for trial this morning, and he's in the midst of picking a jury up there in Isanti County, and so he unfortunately can't be with us today. Just by way of background, Mr. Edblatt, prior to becoming elected our president in December, held a number of executive positions within our association, and then again was elected this past December as our president. Mr. Edblatt served, among other things, he served on the Minnesota Sentencing Guidelines Commission. He's the longest serving member on that commission, served as its chair from 2007 to 2015, and then recently resigned from that commission when he saw that he was going to be elected our president. Let me just tell you a little bit about my background. I have been a prosecutor in the state of Minnesota as an assistant United States attorney for 25 years. After serving 25 years as an assistant United States attorney, I was appointed to the state bench in Hennepin County, where I served for just short of 9 years. Then I hit the dreaded mandatory retirement age, and so I had to step down from the bench. I stepped down from the bench on November 30th of 2014 and started my current position as the executive director on December 1st. So I had a weekend off. Didn't like retirement. I'm sure Senators Anderson and Phelps might agree with that. But in any event, our association consists of about 800 people, the 87 elected county attorneys and their assistants. We've been in existence, at least informally, since Minnesota became a state in 1858. County attorneys were meeting at that time. Formally, however, in 1973, the legislature created what was known as the County Attorneys Council. It consisted of the 87 county attorneys and the Attorney General. And the mission of the council was to strengthen the criminal justice system in Minnesota, and to do that by providing leadership on legal and public policy issues related to the duties of the county attorney, to provide training and continuing legal education for our attorneys as well as law enforcement partners, to gather and disseminate information about changes in the law, whether they came from legislative enactments or changes at the case law level, and to coordinate with law enforcement and the courts and corrections by providing seminars to augment the effectiveness of our criminal justice system. So that was in 1973 when the legislature created the Judicial Council. Then in 1977, the County Attorneys Association became a not-for-profit organization, became formally into existence for a variety of reasons. The County Attorneys Council and the County Attorneys Association merged, and this is what we are today. However, the mission of the County Attorneys Association has remained the same. So there are times that the County Attorneys Association will appear before this committee seeking affirmative legislation. For example, as many of you who served on this committee last year know, and particularly with Senator Latz's assistance, we were very active with our law enforcement partners, with the Defense Bar, with public interest associations, and working with legislators and the legislature to eventually enact the 2016 Drug Reform Act. So that was one time as an example of where we were actively seeking legislation. Another example where we were actively seeking legislation is a couple of years ago. We worked with authors of a bill to increase funding for our association and the training of our attorneys and law enforcement. And you'll see that as a item on your budget when you get that far into the committee, and it's $100,000, and we'll be seeking and hoping that that gets renewed again this session. Another example, and you've heard Mr. Shorba before me talk about the increase in the courts of child protection cases, up 56%. We're feeling that in our offices. The legislation that was passed a couple of years ago placed a significant increase of responsibilities on county attorneys to get more involved in the process earlier in the process, to seek guidance from counsel early in the process, deciding whether it should become an investigation or a family service matter. So we will be coming forward and seeking funds. Senator Schoen, I might be visiting you to see if you might become a co-author on our bill, given your comments. So thank you very much for bringing that up, because it's a very important thing for our association. In addition, we'll be talking about monitoring. You may recall, some of you may recall, that last session, as part of the 2016 Drug Reform Act, there was a justice reinvestment portion. Some money was put in it last year. We would like to monitor that and make sure that some funds get added to it this session as well. So those are examples of when we will be affirmatively appearing before you, seeking action on our legislative agenda. More often, however, we see ourselves as resources for legislators, and to become information givers for legislators as the hundreds of issues come before you. As you know, the duties of the county attorney are set forth in Chapter 388 of our statutes. Just briefly, those duties include acting as the legal advisor for the County Board of Commissioners and any county official and county department, the prosecution of felony crimes, the prosecution of all cases involving juvenile offenders, providing assistance and support to the victims of crime and to the witnesses of crime, each of whom play a vital role in our criminal justice system. And there are family service cases, and you've heard about them, the child protection cases, vulnerable adults. Senator Ingebrigtsen, we might be able to help you out as well on that issue. I think you said it was a vulnerable adult, and county attorneys have some responsibility in making sure vulnerable adults are protected. In addition, in the family service area, we deal with civil commitment to assure that there is proper treatment for those individuals who are mentally ill and or chemically dependent. We also, for those families that are receiving public assistance, we provide assistance in obtaining child support for those families, as well as establishment of paternity. So those are the areas that are included in the duties of the county attorneys. Our association has a committee structure that deals with each of those areas. And so when a bill is introduced that might impact one of those areas, it goes through our committees. And the committees are made up of practitioners in the field who are experts in that particular area. And that committee will provide comments on the bill and a recommendation to our board, and then we will act on whatever the board decides. Another example of a bill where we provided information, where we were not seeking the legislation, but rather was an information resource. For a number of sessions, there have been suggestions to amend the forfeiture laws, and we brought in some assistant county attorneys who actually do this work. They met with the author of the bill. We talked about some of the practicalities of the implications of that bill and the impact of the bill. And then we were able to work with some crafting of some language that the county attorneys would support. Another example, there was a bill introduced a couple of sessions ago dealing with the ability of a family to make religious objections to an autopsy that might be performed by a medical examiner. And we worked very closely with the authors of the bills as well as the various stakeholders to craft language that would recognize that right to a religious objection, the circumstances under which the medical examiner might conduct the autopsy notwithstanding the objection, the process by which those potentially competing interests could be resolved. And we were able to work with everyone to come up with some language that everybody agreed upon that would be a compelling state interest that would allow an autopsy notwithstanding religious objections. And so that was, again, another example of our ability to work with stakeholders, work with legislators, come up with language that was satisfactory to everyone. So those are some of the examples. That's a very broad overview of the County Attorneys Association, and I'd be happy to answer any questions that any members of the committee might have.
Are there any questions? Senator Latz.
Mr. Chairman and Mr. Small, in my experience in the last couple of years, I've heard feedback from law enforcement that they have felt, and from the communities as well, that they felt maybe there could be more training made available to law enforcement officers, both the sheriff's deputies and police on the streets, that are part of what your association members end up working with to prosecute cases. And it would be my intent to seek increased funding, a steadier and larger pool of funds available for peace officer training in Minnesota to expand the kinds of training as well as the availability of it. Any thoughts on that from your perspective?
Mr. Small.
Mr. Chair, Senator Latz, thank you very much for that question. Yes, we have been talking with the Police and Peace Officers Association about training that might be available. I believe we have a member on the Governor's Council for Police and Community Relations, and training has been a significant issue. We are supportive of that. One of the things that we did do, Senator Latz, with respect to law enforcement training when, as you may be aware, when there were changes at both the United States Supreme Court as well as the Minnesota Supreme Court with respect to our DWI laws, we very quickly put on a training session, 2 different locations for over 4,600 law enforcement officers, state troopers, street cops, on how the impact of those decisions, the use of electronic warrants, waking judges up at 2 o'clock in the morning or not. And so we did put on that training. So that was one of the things that we were very thankful we had the additional funding to put those up in Duluth. We did one, and then I believe we did one in the southern part of the state as well. And so we're looking forward to providing that additional training. Thank you.
Any other questions for Mr. Small? Thank you, Mr. Small.
Thank you very much for having us, Mr. Chair.
You're welcome. The next group on the agenda is the Minnesota Board on Judicial Standards, Mr. Tom Vasily. Welcome to the committee. Would you identify yourself for the record?
Good afternoon, Mr. Chair, members of the committee. I'm Tom Vasily, Executive Secretary of the Board on Judicial Standards. Shall I proceed?
Please do.
I'm here to give just an overview on the work of the board. We were formed in 1974 by the legislature as a result of a constitutional amendment. And we operate under the rules of the Minnesota Supreme Court, but we are independent of the judicial branch. There are 10 members on our board appointed by the governor, 4 public members, 4 judges, and 2 lawyers. The current chair is Tim Gephardt, who's an insurance company executive, a member of the public. And the vice chair is Judge David Knutson, who you might recall is a former state senator. What the board does is take action on complaints against judges. The most serious action would be removal from office. You may recall a couple of years ago, Judge Alan Pendleton in Anoka was found to have been living outside his district. Under the Minnesota Constitution, a judge must reside in the district in which the judge serves as a judge. And Judge Pendleton did not. And he also lied about it on his affidavit of candidacy. The board filed charges, and the Minnesota Supreme Court removed him from office. A year or so before that, we had Minnesota Tax Court Judge George Perez, who is not making his decisions by the 90-day deadline. There's a statute that says that a judge must decide cases within 90 days as a general rule. Judge Perez was not doing that and was falsely certifying that he was in many cases. And what happened in that was interesting. When the board files charges against the judge, the Minnesota Supreme Court appoints a panel to hear the charges and determine if they're true. They found in Judge Perez's case the charges were true. And as soon as that happened, the Minnesota legislature acted. Judge Perez's confirmation was pending before the Senate, and within a matter of a day or two, the Senate voted not to confirm him, which meant he was immediately out of his job. In less serious cases, the board will publicly reprimand a judge. That happens a couple of times a year. The most recent case involved Judge Rex Stacy. He's in Scott County. He was publicly reprimanded for berating persons who came before him in court. In the case of misconduct that's isolated and non-serious, the board will issue a private admonition to the judge. All disciplines are preserved in the board's office until the judge's death. Now, one thing we should note is that the board does not review judicial decisions. That's for the Court of Appeals. And that's the most common reason why we dismiss complaints that come to our office. And a lot of the parties are unhappy, very unhappy with the decision they've gotten in court, but there's just not much we can do about that. So if you hear from somebody complaining that the judicial board doesn't do anything, the most likely reason is that they are complaining about a judge's decision. Now, one activity that we do, which doesn't receive a lot of public notice, is to issue advisory opinions to judges. If a judge has an ethics issue before him or her, they can contact me, and I'll do the research. I might contact a member of our board, and we will issue a confidential written opinion to the judge. And this service has been growing in popularity. In 2016, we issued 134 advisory opinions to judges. It's a 50% increase. And in addition to that, we, from time to time, issue formal opinions of general applicability to all judges. And in addition, we have educational programs. For example, last year, we put on a program on how a judge can ethically run for election without violating any of the rules. We have a robust website. The disciplines are posted so that the public and judges can be guided by them. Also, the advisory opinions are posted as well. And so we've got we're very pleased with our website and with the direction that our office has been heading in the last couple of years. Questions?
Senator Hall.
Mr. Chair, and Lassie, is it?
Vasily.
Vasily, thank you. When you have an investigation on a judge and the decisions are made, is that a public discussion? Is that a public, like, I want to use trial, but it's not a trial. But is that public? And is the vote on that judge public for, 5 to 4 or whatever, depending upon how many are there?
Mr. Vasily.
Mr. Chair, Senator Hall, the initial decision whether to prosecute or not prosecute a judge, that's by the board, and that's confidential. But if the board decides to seek discipline, public discipline, it will file public charges with the Minnesota Supreme Court. And the Minnesota Supreme Court will then appoint a 3-judge or 3-person panel, 1 judge, 1 lawyer, and 1 member of the public. And they will hear the case just like a trial. And that's all public.
Okay. Oh, thank you.
Mr. Vasily, is the 1 member of the public on this board, is that an attorney, or could that be someone other than an attorney?
Cannot be an attorney. The member of the public on our board and also on the panel must be neither a judge nor an attorney.
All right. Any other questions? Senator Anderson?
Thank you, Mr. Chair. Mr. Vasily, if a person, just reading through your article here and talking about different things, if a person who has been, comes before a court and they're disabled, and then because of the decision of the court are turned away and they file a complaint with you because of the way it had come down from the judge or whatever the case might be, what happens if they file a complaint with you and they don't get any type of a response back from you? What is it that they are left to do as far as further action?
Mr. Chair, Senator Anderson, first of all, if you're referring to a complaint that the person was discriminated against based on a disability, we would generally take action on that. We would take a look at that. In fact, any form of discrimination or bias would be within our jurisdiction. Now, sometimes somebody will say, the judge is biased against me. And I'll say, well, what is your evidence of that? And the complainant will say, well, he ruled against me. So by definition, from his perspective, if he lost the case, that means the judge is biased. We don't look at that. But if there's other things, for example, if the judge makes inappropriate comments, we generally will open a file and take a look on that. And we have access not only to the transcripts, but we have access to the audios. And so we'll review the audio. Now, what happens if we determine that there's not enough there to justify a prosecution? That's it. We're an independent entity, which means that the judicial branch cannot either make us go after somebody or prevent us from going after somebody. So it's a little like a county prosecutor. If the county prosecutor doesn't believe that there's a case there, that's the end of it. No one can force that county attorney to prosecute.
Thank you, Mr. Chair.
Senator Anderson.
So if they don't get a reasonable jurisdiction from the judge and they file a complaint with you, you find you don't have any, can they go someplace else? Is there an ombudsman or somebody else that they can file another complaint?
Mr. Vasily.
Mr. Chair, Senator Anderson, the answer is no. We are the only entity that has the authority to go after judges. So that's why the work we do is critical. Now, if we don't take action against a judge, there are other potential avenues, but they generally are ineffective. If the judge has committed criminal conduct, they may file a complaint with the police or a county attorney. If the judge has violated their civil rights in some way, there is at least theoretically the possibility of a civil lawsuit against the judge. But as a practical matter, if you lose your case in court, and also if the judicial board does not take action, in most instances, you do not have an additional remedy.
Senator Schoen.
Thank you, Mr. Chair and Mr. Vasily. I guess I'm kind of curious about, is there any formula or rationalization between public shaming and private admonishment to long-term, and this kind of goes into maybe a bit of Senator Anderson's question. Really, how much consequence do those actually carry? And then secondly, Senator Limmer, does this board, well, it doesn't seem that it would. So you only would work with sitting judges. Would there be any action that would be taken that could be brought to this board that would prevent someone from being a judge?
Mr. Vasily.
Mr. Chair, Senator, it has been the conventional wisdom that if you receive a reprimand from our board, you're in deep trouble at the next election. And in the past, judges have, as soon as our board has publicly reprimanded a judge, the judge will find himself or herself with an election opponent. And judges have been defeated. Though, interestingly, the last two public reprimands we issued, it brought out the challengers as expected, but in both instances, the judge did survive. So it's not a death knell, but it certainly makes it difficult for the judge. As you know, usually judges either run unopposed, or if they are opposed, the judge wins handily. But if our board takes action against the judge, that's not always the case. And I'm sorry, Senator, I think there's more to your question I didn't answer.
Senator Schoen.
Mr. Chair and Mr. Vasily, my question was based around, you have a candidate who is, or potentially someone who wants to seek a seat on the Supreme Court or another judgeship. And does your board have any teeth to prevent someone from being a judge, or prevent them, take action that would just bar them from the candidacy, maybe?
Mr. Vasily.
Mr. Chair, Senator, if a judge has been removed from office, as was the case with Judge Pendleton, they are forever barred from seeking judicial office in Minnesota. If a judge has lesser form of discipline, they may. However, if a district court judge seeks, for example, appointment to the Court of Appeals, the judge will be asked to sign a waiver that will permit my office to give the governor's office the disciplinary history on that judge, including the private history. So if a judge has a record of private discipline, the governor is going to know about that and very probably would enter into the governor's decision.
Senator Ingebrigtsen.
Thank you, Mr. Vasily. I'm wondering, I've got a couple of questions, but I think you've cleared a couple of them up just by the testimony. But should there, I did have a jurisdiction, not a jurisdictional, but a selection process that's strictly done by the judge, is that correct? Or excuse me, by the governor? Is that correct? The selection of the board?
Mr. Vasily.
Mr. Chair, Senator Ingebrigtsen, that is correct. It's the governor who appoints all 10 members.
Okay. And thank you, Mr. Chair. And
Senator
a follow-up. So if you and eventually we will have a new governor, I mean, that's pretty clear. Do all of those positions go away and get reappointed, or do you have any institutional knowledge, any folks that actually stay, or are they on term limits, or are they just totally now have to be reappointed by the judge, all members? Or, excuse me, by the governor?
Mr. Vasily.
Mr. Chair, Senator Engelbretson, the answer is no, they're not automatically kicked out when the new governor arrives. There are staggered terms. There are, I believe, 2 positions that are going to be available this year, and more positions will be available in the future years.
So thank you, Mr. Chair. So there is just a process then. I guess the term limit thing is what there is. So we're not just sitting with 10 new members with a new governor coming in then. So I think you answered that. Thank you.
Thank you. Are there further questions? Senator Anderson?
Thank you, Mr. Chair. I kind of piggyback on what Senator Engelbretson was asking regarding the appointing by the governor. Do you, Mr. Vasily, then get appointed as the executive director by those members that get, how is your position determined, or do you get appointed by the governor also?
Mr. Vasily.
Mr. Chair, Senator Anderson, I am appointed by the board members, not by the governor, and I'm at will. I serve at their pleasure.
Mr. Chair.
Senator Anderson.
One last question. Just from your perspective, do you like the process of the way the governor has chosen, any governor has chosen the members of the board? I'm wondering, because there are complaints about other entities that get the governor's appointment, not just this one, but in past things. I'm just, from your vantage point, do you like the process, or would you like to see something changed?
Mr. Vasily.
Mr. Chair, Senator Anderson, the process, as far as I can tell, works great. Both Governor Layton and before him Governor Pawlenty appointed board members based on merit. They come from both political parties, but neither governor had a litmus test. And so the board members are there because they're competent. And so we have a number of representatives from both parties. And in the cases of judges, I'll have to say former representatives, because they do not identify themselves anymore once they become a judge as being a member of a party. But I have to say that the board right now is unusually collegial, works very well together, despite the fact that you have people not only from different parties, but from different walks of life. So I know that I've heard that in years past, there have at times been conflicts on the board, but in recent years, I can't say enough positive about the board. We've got some wonderful members, and both Tim Gephardt, the chair, and former Senator David Knudsen, I assume you know him, I have extremely high opinions of.
Okay. Senator Hall.
Thank you, Mr. Chair. And Mr. Vasily, it sounded like what you were saying is that if a senator or representative becomes a judge, that because he changes the name, it's a step up. Would that be correct?
Yeah, Mr. Vasily, why don't you answer that?
Mr. Chairman, I recommend that he plead the Fifth Amendment.
Well taken, Senator Latz.
Mr. Chair, Senator Hall.
One moment. Senator Latz, or Senator Hall, is that just a rhetorical point you're making?
Oh, I'm sure it was. Thank you.
Okay, you don't have to answer that, Mr. Vasily.
Thank you, I'm relieved.
Hearing no other questions and moving along quickly, and I don't think there are any other questions, Mr. Vasily. You're excused. Thank you for coming.
Thank you, Mr. Chairman.
Before we adjourn, just in closing, you will notice, members, that this committee is meeting 3 days a week for an hour and a half each time, and we're trying to avoid really long committees that were previously reserved for 2 days a week. And hopefully, we can get most of our work done without getting into long, late-night meetings that were rather typical of the judiciary pattern. That's not to say that we're going to avoid those entirely, especially during deadline week, but we're just trying something new this session. The other issue, tomorrow we'll be hearing portions of our first bill, and that would be Senate File 1. That's on the health care premium issue that many of our citizens are experiencing right now. Senator Latz, I mentioned to you earlier before this meeting that I was hoping to get you an amendment to handle what I thought was technical. I was told by research that it's a little more beyond technical, but they do not have the amendment finished at this time. So as soon as it's done, I've instructed them to get a copy to you, and, well, might as well send it to all members so you can review it and have time to review it. So other than that, one message to Republican members: there'll be a brief meeting in my office immediately after this committee hearing. And other than that, I don't believe there's any other issues before the committee. And hearing, Senator Schoen.
Well, thank you, Mr. Chair. Thank you, Mr. Chair. Can you give, so as we're looking at Senate File 1, can you give a highlight under what sections that we're going to be reviewing? I assume some of it's, is it related to the data area? And then what particular portions that what it'll cover? Because I know that it's certainly, that particular bill, I did spend a few years on healthcare, and it's certainly much more than just premium relief.
Senator Schoen, thank you for the question. I was instructed, I'm confusing what has been billed as priority 1 with a Senate file number. It's actually Senate File 55. 55 members. And Ms. Pontius, would you be able to answer Senator Schoen's question regarding what section and article the contention is that the amendment is being prepared for?
Yeah, Mr. Chairman, Senator Schoen, if you look at Senate File 55, it basically pulls some of the data language out of Senate File 1. So that's what the committee will be focusing on. We've identified a few other components that might need to be added to that, but I think in general you can see the thrust of it if you look at Senate File 55.
All right. And we'll try and have research get that information to you as soon as possible for all our members. Senator Latz.
Mr. Chairman, do we expect to have that by the end of the day? I mean, we're trying to move or I should say the majority is trying to move a very complicated bill through 3 different committees in one day by splitting it up into several different Senate files, and not having an amendment, even at this point in the process, is going to put the process at a disadvantage in terms of being able to evaluate the impact of what it will not be a technical amendment. At least we've seen the language in Senate File 1 so
55.
Far. Senate File 55, which pulls the language out, the data retention language out of Senate File 1. So it's essentially the same thing, but for this amendment that is on its way. We're moving awfully fast here. When do you expect we'll see that amendment?
Ms. Pontius.
Yeah, Mr. Chairman, Senator Latz, I've been working on it now. The amendment isn't a major policy shift. I can just tell you a couple of things because it really is more technical in terms of its approach. There's data being collected in the bill right now that's not classified anywhere, and it's what would normally be considered private data on individuals, like the people who are submitting their applications to get the premium assistance. There's nothing that classifies that data, so the amendment would classify the data. There's also language that's in Senate File 1 right now under which the health plan companies are required to submit a lot of information on all of their enrollees to management and budget. And that was sort of another issue to look at in terms of classification of the data. So the amendment will add that language and classify that data as well. So that's kind of the gist of what the amendment will do.
And Ms. Pontius, when do you think you would be able to get a copy of that amendment and perhaps an explanation to members?
Mr. Chair, we can work on it, try to get it by the end of the day.
All right. Senator Latz.
Well, Mr. Chairman, I think the public should be on notice that it seems to be this committee's intent to take up a complicated data privacy, multi-pronged data privacy provision for 1.5 hours on the second day of committee hearings for this committee, with very far-reaching implications. And I, for one, am skeptical that we can do an adequate job reviewing that. The chair knows very well and has been very keen on the importance of data privacy issues, as have I over the years we've served together on this committee, and the hours that we have spent parsing language and implications. So I'm a bit skeptical that we can do adequate justice to this important policy question in tomorrow's hearing, but I guess we'll see what transpires.
Your comments are well taken, Senator Latz. Is there any other business before the committee? Hearing none, committee's adjourned.